Yeah, good day and compliment their esteemed viewer and welcome to our today's edition of Citizens and the Law on ABS Television, Channel 24, Oka, also on Star Times 113 and Metro Digital 29. Citizens and the Law is a program aimed at letting the citizens know their right, defend these rights, as well as becoming law-abiding citizens. In our today's episode of Citizens and the Law, we are going to look at another important topic, hearsay. And I have with me here in the studio a gentleman from the Nigerian bar, a legal personality, to get all the I's and T's dotted across to vis-a-vis a provision of answers to all the questions. I have with me here in the studio, Barrister Isaac Ofodile. Counsel, you're welcome to the studio.
Thank you very much.
Okay, I am the presenter of the program. Jude Mascot Biago is my name. Like I said, the topic for today is hearsay. So, Counsel, a lot of us used to hear this word, hearsay. Some say hearsay. Now, if I know hearsay, things like that. But here, I have you in the studio as a lawyer to legally tell us what the law regards or call hearsay. So what is it? What is hearsay?
Hearsay in law is one of the branches or types of evidence, although indirect. Now, when you talk about hearsay, you talk about those statements, either oral or written, that was made by a person that was not called as a witness in court. That is to say, the person that made the statement is not the originator of the statement.
Okay.
In English, it is called an indirect speech.
Okay.
It is not a statement that comes straight from the person who said it. You know, if you look into our Evidence Act, particularly Section 126, you discover that the law allows you to give evidence of a fact you perceived, if it's an evidence of a fact that is perceivable. But if it's an evidence of a fact that that is heard through the auditory canal, then it must be an evidence of a person who heard it. If it's an evidence of a person who saw, or if it's something capable of seeing, it must be an evidence of a person who saw it. So anything outside a direct oral evidence, then it has to be called hearsay in law. That is what we know as hearsay. Hearsay can be oral or documentary. It is not a straitjacket issue. It is either oral or, so that's why you have documentary hearsay or oral hearsay.
Okay. Let's go on a short break. We'll be right back. I will ask you the next question. After this question, I will go to the DP of Figure Police Station. I interviewed him on this hearsay, and there was something he said. But then before that, I want you to look at the acceptability of this hearsay in court. Now the question will go this way: are there conditions hearsay could be accepted in court?
There are conditions.
Okay, get them enumerated.
Hearsay can be accepted in court.
Go on, go on.
Basically, there are 4.
Okay.
If you look into our Evidence Act, particularly section from 37 to 40, it enumerated the 4 conditions wherein hearsay may be accepted by the court. Now, if you check section 37, section 37(1) says generally that hearsay is inadmissible. So if hearsay is generally inadmissible, that means the acceptability falls under the exceptions. One of them is a statement of a dying person, otherwise known as a dying declaration. In that instance, the court may accept hearsay evidence of a dying person. However, you must strictly prove to the court that those words with exactitude that the man that was dying that made the statement, you must prove to the court in exactitude of words what he said. It is not enough to say Mr. A said while he was dying. Meanwhile, there are other instances, for instance, where you go under the issue of a person who can no longer be called or incapable of testifying in court. Such a person, if you take his evidence given by another is hearsay evidence, but it's admissible in law. Why? Because he is incapable of, maybe by act of God, he was speaking before, at a point he can no longer talk. Even gesticulation, he finds it difficult to do. But in that instance, the court can admit hearsay evidence given by the person as at the time he was talking. Then, another one is hearsay evidence given on behalf of a person who is incapable of coming to testify. That is to say, the person cannot be brought to court. And it is practically difficult for the court to move to the place where the person may be. Another instance where hearsay evidence may be admissible is if the person is outside Nigeria. And it is difficult or reasonably expenses may be made. Or there were efforts made to bring in the person, but it proved abortive. It is not only difficult, it's more or less impossible. In that instance, the court can admit hearsay evidence, provided it's relevant.
Okay.
Yes.
Okay, let's a little bit move away and get in contact with the interview on Rabiu Garuba. Let's hear what he has to say about hearsay.
Evidence can be defined from different perspectives, but in this vein I'm going to look at the definition that encapsulates all the elements in evidence. In proving a matter before court, the burden lies on the prosecution, especially in criminal cases, to prove their case beyond reasonable doubt. And in proving your case, you have to tender what is called evidence. And evidence can be defined as all legal means exclusive of mere argument, which tends to prove or disprove a matter of fact, the truth which is submitted for judicial investigation. So in this vein, you can see evidence is of twofold. It's either to prove that the fact exists or the fact does not exist. In this vein, now the prosecution is left with responsibility to prove that the fact exists, while the accused person is tendering only evidence to prove his deniers and to show that the fact does not exist. So this evidence has been subdivided into 3. We have oral evidence, we have documentary evidence, and we have the real evidence. So this oral evidence is the evidence by witness based on what is perceived from his 5 common senses, while documentary is a presentation of document for court inspection to prove whether the fact exists or it does not exist, while real evidence is tendering of any physical object in connection to the commission of crime. So this oral evidence, being evidence given by the word of mouth, is where a competent witness, under Section 155 of the Evidence Act, Cap 112 Laws of the Federation 1990, appear before the court to give a testimony of what he heard. So, but in some cases, Some are direct and some are indirect. Direct is what you perceive with your five common senses, while indirect oral evidence is the evidence of what you heard another person saying. And what another person is saying is known as hearsay evidence. So hearsay evidence is the evidence of witness based on what he heard another person saying. Indirectly in English we call it reported speech. So this, in the general rule, hearsay evidence is generally inadmissible in evidence. But what we say, in every general rule, there must be an exception. Why this hearsay evidence is not admissible? Simply because the court cannot assess the appearance and demeanor of the maker of that evidence. What I mean in this sense is that if you appear before court physically and give what you say directly, the court will assess your validity and see whether what you said is true, corroborated with the fact at hand, so that the court will now believe that there is an element of truth. But in the reported speech, the court didn't have an opportunity to see the actual maker of that evidence. So that is one part. So, but there is an exception to this general rule, more especially under Section 33, subsection 1 of the Evidence Act 112 Laws of the Federation 1990. These are the situations in case of dying declaration. Dying declaration is a statement made by dying or injured person who has no hope of recovery, stating or suggesting the cause of his death. So dying declaration, like somebody that is injured and he believes that he will not survive, and he make a declaration. So such declaration is known as dying declaration. So dying declaration is not relevant. It is only admissible in the case of murder or manslaughter. Then in the case of murder, there is a murder under Section 316, manslaughter Section 317 of the Criminal Code law. So it's related to death. Somebody will not be dying and say, I have money in the bank, or I have a transaction with someone. This is not dying declaration. Dying declaration is only to the person that is at the dying point, stating about the cause of his death. So in dying declaration, once there is a hope of recovery, once there is a hope of recovery by the person who is dying, it's not a dying.
Yeah, well, there is one or two things that happened there, and we have to decide to cut off the interview. But however, he has been able to say one or two things about hearsay to the extent of a dying person, oral evidence, and all that. So what I may have to do now is to get back to Barrister Isaac Ofodile, who is here in the studio with me, whether he will accept entirely or whether he will put up some arrangement or things like that. So, Barrister Isaac Ofodile, do you accept, or is there anything that needs to be amended in what he presented there? That was the DPO, Federal Police Station, CSP Rabi Garba. Okay.
I agree with my friend. You know, the last time I was in the studio with him,
Yeah.
I agree with him just with little modification.
Okay.
His position is very clear.
Yeah.
However, he was citing Evidence Act, Law of the Federation of Nigeria, 1990. My good friend, I know he is an up-to-date man. From the way he sounded the previous time he was in the studio with me, I know he's a tech man too. The Evidence Act has been amended. So what we have in place now is Evidence Act 2011 as amended.
Okay.
So, but the sections he cited, of course, if you read the old cases, you will still see the sections he cited reflecting. But since after 2011, Evidence Act has shifted the position of, or the provision of the section from section 33 to 37. So from 37 to 40 into 58, that was where the issue of hearsay was dealt with. Now, if you talk about hearsay once more, you talk about statements made by persons who are not called. Ordinarily, what the law looks at is, if you must give an evidence, you must come. Come, let us hear you. It must be a statement from a person who witnessed an event. It is not a reported speech. It is not an indirect speech. That's why generally, before the court can admit evidence of a hearsay, or evidence otherwise known as hearsay, it must be under certain conditions. The court doesn't just admit hearsay evidence. No. The court have to look critically. If it doesn't fall under those conditions stipulated under Section 39, sub A, B, C, and D, you cannot. The court cannot admit it.
Okay. For want of time, I know that the amendment of 1990 and 2011, they are not too far.
Yes.
They still reflect almost the same meaning.
Yes.
Okay, now, I want to ask you this now again. Can you reflect on other types of evidences?
Generally, evidence is divided into two.
Yeah.
It can be direct, it can be indirect. It can be oral, it can be written. It can be real, it can be otherwise. However, there are sectionalized types of evidence. Direct evidence are those evidence that were witnessed, or those facts that were witnessed by a person who had or who saw or who perceived it. Indirect evidence are evidence like hearsay. Like my friend Garuba explained, real evidence are those items. When you talk about real, it must be something you must have seen with your eyes. It must be an item, maybe it was used during robbery, or something that was used during arson, or something that was used in a civil case.
Yeah.
Yes. These are the classes of evidence we have under the Nigerian legal system.
Okay. Go ahead.
Now, you look at oral evidence. There are criteria the court must look at before oral evidence is admitted. The court just not admit evidence of a direct testimony if it is not relevant. If you look under Part 3 of our Evidence Act, what guides the admissibility of evidence in court is relevancy. In fact, Section 14 was being ridiculous with its provision. It says, even when the evidence is stolen. So even if it was wrongfully obtained, what matters is irrelevant to the proceedings. Once it's relevant, it's admissible. Yes.
Now, in case of this dying person, how does the courts look at the statement of a dying person?
The court takes seriously, when I mean seriously, very serious, the statement of a dying person. The court doesn't just swallow, because it is not easy to say, Obi said so and so thing while he was dying. Remember, in our law, it is called dying declaration. Although Section 40 stipulated under the Evidence Act, it is the provision that provides for the admission of or admissibility of evidence of a dying person.
Yeah.
So the court takes serious look, because there is no other person who can deny except the man who is making the statement in court.
Yeah.
Take, for instance, you are saying, I said. How do you determine whether truly I said it? Especially in a situation where you cannot even call me again. A dying declaration, remember, is a statement made by a person who is in the danger of death, or whose death occurred as a result of the injury inflicted by him, or inflicted upon him rather. Then, for it to be admissible, it is not easy for the court. But the court must record in strict words what the person said. That is to say, what the disease said. It is not enough to say, he said. You must say strictly those words that were used by the disease as at the time of his death. So the court looks seriously at what the dying person said. So it must be proved strictly. It is
person must be recorded via handset or mobile handset,
no,
things like that. Or
what the law says.
if you said the person must strictly provide what the person said, must it be in written form or a recorded form? Recorded, I mean, electronically.
Ordinarily, when someone is about to die, there is always not a sign. That's why sometimes death occurs by accident, unexpected.
Yeah.
Hence, if the person is dying, if you say he made a statement, you have to say how that statement was written.
Okay.
You mustn't record it. But if you have an opportunity of recording it, why not? You record it.
The court will admit it.
Yes. But before the court admits it, the court takes a strict look. When I say strict judicial look at it.
Okay.
Yes.
Vis-a-vis. With respect to what and what? Judicial look at it.
Judicial look at it in the sense that it must, for it to be admitted, there must be some kind of corroboration.
Yeah.
So it is not just admitting the statement of a dying person. It must be corroborated by some other extenuating evidence, either real or otherwise, or documentary, as the case may be.
Okay, VC Citizens and the Law on ABS, Television Channel 2 for Oka on Star Times, 113 and Metro Digital 29. Well, if you may still get us, you can send text messages, ask your questions, phone call will return in a short while, but not for today. But if you can just quickly send a text message and ask or pose a question to Barrister Affordile, you can do that on the number topmost there, 090237 73484, 090237 73484. You can ask your question immediately. Okay, before we expect to get your question, let's go on a short break. Well, unfortunately, there is viewer time is up and off, gone in our today's episode of Citizens and the Law. The topic has been Hearsay in Law, and it has been Barrister Isaac Affordile here with me in the studio, who actually steered the wheel of the program today very well. He's busy providing answers to the questions posed at him to justify today's episode of the program. And next Monday, we are coming back with another interesting package of Citizens and the Law. So, Counsel Isaac Affordile, Barrister Isaac Affordile, thank you very much for coming.
It's my pleasure.
You're always up there in Abuja.
It's my
you
pleasure.
have chance to come back here in the studio in the shortest possible time. I am Jude Mascot, to be with the presenter of this program. Until next Monday, it's bye for now.